Apportioning damages in actions involving reckless conduct. My name is Megan Cook. I'm a shareholder at Hauser and also pleased to be a member of the OADC board. I'll be moderating today's presentation. One of our first presenters is Jonathan Henderson of Aaron Landau and Sarah Tuthill-Kveton. Jonathan is a shareholder at Davis Rothwell and specializes in civil appeals and handles appellate matters involving a wide range of issues. He has years of experience arguing motions in Oregon trial courts around the state. He's also handled dozens of appellate matters in the Oregon and Washington Courts of Appeal, the Oregon Supreme Court, and the Ninth Circuit Court of Appeals, receiving favorable published decisions from each. Aaron Landau is a shareholder at Harrang, Gary Rudnick, and his practice is focused on appeals of civil litigation and disputes of public law. His appellate practice includes representing both public and private clients in appeals of civil litigation, with a particular focus on matters of constitutional and public law. His practice also has included a broad variety of business disputes, including employment, healthcare, and product liability issues. Sarah is a partner at Chock Barhoum and has had a variety in a legal background with defense experience ranging from motor vehicle collisions, premise liability claims, professional malpractice, personal injury, contract disputes, timber trespass, dram shop, and medical malpractice. She defends clients in both Washington and Oregon. Sarah started her career as a public defender, where she spent several years gaining valuable experience in the courtroom. I want to thank Jonathan, Aaron, and Sarah for being willing to appear by Zoom to present today. I know a lot of us are anxious to hear about the Miller decision and what that means for our practice. Before we get started, I would like to quickly walk through some housekeeping items. Please, your microphones and video are muted for the webinar. If you have a question, please enter it in the chat section. I'll be monitoring that section throughout the presentations and can relay those to our presenters. We'll try to answer as many questions as possible in the time allowed. We're also applying for CLE credits and recording the presentation to be made available at a later date. We'll circulate the presentation materials, details on how to receive the CLE credit, and contact information via an email after the webinar. With that, we will go ahead and start the presentation. Thank you.
Thanks to OADC for having us. I wish we were presenting under more auspicious circumstances. It's a lot more fun to be talking about a case that you won and that bodes well and promises happy returns, and this is not that case. It's not earth-shattering either, but it's worth talking about, and I think that's why we're here. At the suggestion of Jonathan and Sarah, I'm going to take up the first chunk of time. It'll take us to, I'm guessing, 12:25 or 12:30 or so, and then Jonathan and Sarah will add their own thoughts about this case and its implications, and then if we have time after that, we can discuss any questions, concerns, comments from the audience. On that note, this case, I'd like to think people have some thoughts about this one. I'd really encourage folks to chime in and use the chat box with questions, suggestions, or here's what I think. I think this is a topic that really would benefit from that kind of discussion. So have at it. This is about Miller versus Agripac, decided by the Court of Appeals about 2 months ago. But before I get to talking about Miller, and the reason that that Jonathan and Sarah asked me to talk first about that is because our firm represented the sole defendant in that case on appeal, Kaiser Gypsum, and continue to represent the client for purposes of a petition for review. But before I get there, kind of have to cover two preliminary subjects, and one is the statutory background, and the other is a Supreme Court case from 2019 called Gutierrez Medina, and then we'll have a little better sense of where cases like this one come from and why we're seeing a lot more of them in recent years, and I think we'll see more to come. And then I can talk about what I think are some key takeaways for the defense bar going forward. First, as for the statutory background, you all probably know already common law defendants that caused a defendant's injury or a plaintiff's injury were jointly and severally liable way back when, even if each one was just negligent. That, of course, means that each one of them is going to be liable for the entirety of plaintiff's harm, not just their share, which is the alternative, several only liability. Also at common law, way back when, the defense of contributory negligence precluded a plaintiff from recovering at all in negligence if the plaintiff's own negligence contributed at all to the harm. So even if it's 1% and 99%, recovery would be barred altogether. So all of that fell kind of out of vogue in the 60s and 70s. And in Oregon in the 70s, our legislature created the statutory defense of comparative fault, following the trend of a whole bunch of other states, to replace that old common law doctrine of contributory negligence. And under that comparative fault system, which is what we still operate under today, a negligent plaintiff can recover even if it was negligent himself or herself, so long as the plaintiff's negligence is less than the defendant's negligence. And so it's okay if plaintiff's negligence contributed 25% or so, but plaintiff's recovery is then reduced accordingly. Around that same time in the 70s, the legislature also created a framework for apportioning fault among multiple defendants. And that involved having the trier of fact, usually the jury, determine the degree of each one of those defendants' fault as a percentage of the total. That system is still in place. It's at 31, 600, and 605. And so under comparative fault, we're comparing the defendant's own fault with A, all the other defendants sued or not, settled or not, and B, the plaintiff. The last part of the statutory history is that in 1995, the legislature abolished joint and several liability entirely in personal injury cases, with certain exceptions, and for all cases arising on or after the date in 1995 when that law was passed. That too is still in place. It's 31-610. So that's the statutory background. But there's, I think, one more piece of common law background that's important, and that is there is an infinite variety of things that a defendant can be sued for in tort in a personal injury case, but the courts like to say that there are 4 categories into which all of that conduct falls. Everything falls into 4 boxes. 1, simple negligence, and we're familiar with that. 2 is gross negligence. 3 is wanton conduct, and 4 is intentional tort. In general, the way that those are described is, we know negligence is acting in a way that creates a foreseeable risk of harm. The second category, less common, gross negligence, usually is distinguished by saying the risk of harm is substantial and the defendant consciously disregarded that risk. The third category, wanton, sometimes called willful and wanton, is distinct because the defendant, to act wantonly, the defendant consciously disregarded not just a risk of harm, but a high probability that substantial harm will result. So what you're doing will very probably cause substantial harm, and then you do it anyway. And intent, of course, is the fourth. Stepping back for a moment to the old common law stuff we were talking about, the old defense of contributory negligence was available only if the defendant engaged in conduct of that first or second type, negligence, gross negligence, but not the second two, wanton or intentional torts. In a bunch of cases that started in the late 70s forward, our courts have pretty consistently concluded that that statutory framework of comparative fault that we were just talking about is intended to follow that same distinction between boxes 1 and 2 and boxes 3 and 4. So the comparative fault scheme is available only for a defendant who's negligent or grossly negligent, but it's unavailable where the defendant engages in either of the other categories, wanton or intentional conduct. And we can kind of see why that would be true, why wanton conduct is kind of lumped in with intentional tort, because at least in my opinion, as between a defendant who knows his conduct will very probably result in significant harm to the plaintiff and then does it anyway, and a defendant who takes action intending to cause harm, there's really not a whole lot of daylight there. There's not a lot of conceptual distinction. It doesn't, both of them are in effect deliberately engaging in harm. And when that harm results, courts say neither one should be entitled to the benefit of comparative fault. And that makes sense enough. All of that is the background, but it leaves unanswered, okay, what does recklessness mean? For most of the last century in Oregon and lots of other states, cases have been ridiculously inconsistent about what recklessness means. Some have suggested it means wanton, some have suggested it means grossly negligent, some have said it's somewhere in between. Oregon has a statute that defines what recklessness means, but really only for the criminal context. Overall, the modern trend, setting this case to the side for a minute, overall, the modern trend is to say recklessness falls below that dividing line, falls somewhere below the line between boxes 1 and 2 and boxes 3 and 4, so that recklessness doesn't make if the defendant is reckless, comparative fault can still come into play. In 1999 case, Court of Appeals called Hampton Tree Farms said really explicitly, recklessness belongs on the lower side of that line because it's a form of negligence, not a form of wanton or intentional tort. So that's kind of where the case law was going. That brings us to Gutierrez-Medina, which is a 2019 case. That's a criminal case involving a drunk driver who struck a pedestrian who was jaywalking at night. The defendant was convicted of Dewey and third degree assault, and he was ordered to pay like 150 grand in restitution. He argued on appeal, restitution is really a civil-ish remedy. And so the sentencing court should apply the civil law defense of comparative fault and determine how much plaintiff is responsible for his own injury by jaywalking at night. It went all the way to the Supreme Court, and the Supreme Court said, okay, assuming without deciding that you're right, that this whole scheme applies generally to restitution because restitution is a civil-ish remedy. The court said, even so, if a defendant's conduct was equivalent to at least wanton, so in those third or fourth boxes, then the framework is unavailable anyway. So let's take a close look at what the criminal defendant did, what he was convicted of, and figure out whether that looks like wanton or intentional conduct. And if so, that whole comparative fault scheme isn't going to apply anyway. And so the court took a close look at what he was convicted of, which included by statute that the act would cause serious physical injury. By statute required that he use a deadly or dangerous weapon, presenting a substantial and unjustifiable risk of serious physical injury, that the defendant was aware of and consciously disregarded that risk. The Supreme Court said that sounds a lot like wanton conduct to me. And so concluded that that defendant's conduct, what the defendant was convicted of, took him out of the realm of comparative fault because it looked like that third box at least. The plaintiff's bar looked at Gutierrez-Medina and said, so recklessness is wantonness. The reason they said that is because this guy was convicted under a statute for third degree assault defined as recklessly causing serious physical injury to another by means of a deadly or dangerous weapon. A lot of plaintiff's lawyers looked at that and said, okay, so you're telling me reckless means wanton. Interesting. I don't think that's quite what Gutierrez-Medina said, but that is what has caused more litigation like the case that we're about to talk about, Miller. So that kind of brings us all to where we are now, that the idea is if you allege the defendant was reckless, that and prove that the defendant was reckless, that you can make comparative fault frameworks unavailable and effectively hold that defendant jointly and severally liable. And then the jury is never going to be asked about other defendants. So here's what happened in Miller. Donald Miller was a third generation asbestos worker. His exposure started literally when he was a baby through age 36, at home, with family, at school, in the Navy, through a bunch of jobs. He was diagnosed with mesothelioma in 2019. Right after that, he and his wife sued 50 some odd defendants for the harm that plaintiffs said was the result of this 36-year-long exposure to asbestos. They sued dozens of manufacturers and distributors and suppliers of products that he'd been exposed to, owners of premises, Navy folks, other defendants, a wide variety. As that litigation proceeded, things got narrower, people got dismissed, people settled out. And on the eve of trial, the only defendant left was our client, Kaiser Gypsum. Plaintiff's case against Kaiser was a whole lot narrower than their case against everyone else. In contrast to this 36-year-long variety of conduct, and what was up against our client was this very brief period during which the guy was employed on the very late 60s doing construction work. He didn't use asbestos products himself, but he was around others who used a particular drywall joint compound that our client made at the time that contained asbestos. He brought two claims against Kaiser. One was negligence, the other was strict products liability. His wife brought a claim for loss of consortium. Ordinarily, as we were just discussing, the tort liability of that kind of defendant is going to be several, not joint and several. And so the law would permit a defendant like our client to put on evidence of the conduct of other defendants, including those who have settled, have the jury determine the extent to which those other parties, present or not, are responsible for the plaintiff's harm, and then impose damages against the negligent defendant only in proportion to that company's share of the harm, which makes a big difference in a case like this, where you have 50 some odd defendants whom plaintiffs said were responsible for plaintiff's harm. Plaintiffs had a different plan. They wanted Kaiser alone to be held jointly and severally liable for all of the harm, because we were the only client left, we were the only defendant left. They did that by like two separate mechanisms. One, they amended their complaint just before trial to add an allegation that said also the defendants were reckless and wanton, and therefore the comparative fault statutes don't apply. The second was they filed a motion in limine asking the court to conclude that because the 1995 law abolishing joint and several liability applied only to cases arising on or after 95, plaintiffs said this claim didn't arise on or after 1995. This claim arose back in the 60s when he was exposed to asbestos. We disagreed. We said it's clear under about 100 years of unbroken Oregon case law that a claim arises when the plaintiff discovers actionable harm, but we lost that point. Plaintiffs won both of those points, and the matter went to trial. That we also filed a directed verdict motion saying, in any event, this allegation that the defendant was wanton requires that you show the defendant knew that the conduct was such that the very probable outcome was substantial physical harm. What we're talking about here is at best negligence. We're not talking about the kind of, I know that what I'm about to do is very probably going to result in substantial harm to the plaintiff, and yet I'm going to do it anyway. We're talking about, for example, failure to warn, sort of commonplace product liability claims. And that motion said, by the way, Kaiser Gypsum went through bankruptcy. Its assets were spread to the winds. And And so the bankruptcy court required that all plaintiffs who wanted to sue Kaiser Gypsum sign an agreement saying, we're not going to sue Kaiser Gypsum for anything other than what its insurance policies would cover. So you can't go after its own assets, you can only go after its insurance policies. We said, what you're describing here is wanton conduct. You're describing wantonness under Oregon law, and that is the third box of conduct. That is knowing that what you're about to do is gonna cause serious physical injury and then doing it anyway. That's not the kind of thing insurance covers, right? You're never going to get an insurance policy that covers that, and Kaiser didn't. And so we said you're alleging wantonness in effect, and you can't do that because you agreed not to. In response, the plaintiffs told the court, okay, we're abandoning the allegation that Kaiser's conduct was wanton. They say the plaintiffs state that they are withdrawing their allegation of wanton conduct and instead proceed as to reckless conduct only. Well, that's interesting because it tees up really squarely. What's the difference? If they say we're abandoning our allegation of wanton conduct and we are proceeding only as to reckless conduct instead, what's the difference? Because remember, recklessness is one of those things, it doesn't really fall neatly into any one of those four boxes, and the court's been really inconsistent about what it means. We lost the directed verdict motion. The jury was, despite the fact that the plaintiffs had withdrawn their allegation of wanton conduct, the jury was instructed to find instructed to determine whether the defendant engaged in reckless conduct, but then defined reckless conduct the way that Oregon defines that third box, which is wanton. We said that's not reckless, that's wanton. You can't just call it by a different name. Trial court said no, that's appropriate, and the jury returned a verdict for plaintiffs on all three claims. We raised 3 assignments of error on appeal. The first was that the trial court was wrong to conclude that this claim arose back in the 60s, because claims arise when you discover actionable harm. The second was that the trial court erred in directing the jury to determine whether Kaiser was reckless, defined as wanton, because those aren't the same thing. You're defining one thing but calling it another. And the definition that you're using is an allegation the plaintiffs expressly withdrew. And the third, we said that the trial court erred in denying the motion for directed verdict because there just wasn't evidence to show that that there was wanton conduct anyway. The Court of Appeals began in this case by rejecting the second assignment of error. They kind of jumped over the first assignment of error concerning when a claim arises and moved directly to the second assignment concerning the jury's instruction on recklessness. As to having the jury decide whether Kaiser engaged in what is effectively wanton misconduct, even after the plaintiffs had expressly withdrawn that allegation, the Court of Appeals said, too bad. They concluded that plaintiffs' withdrawal just concerned the label, but not the subject, and that the substance of that allegation was correctly describing what the Court of Appeals said can be called either wanton or reckless, because, quote, wanton and reckless are alternative terms for the same category of conduct. That is something that an Oregon court has never said before. And certainly Gutierrez Medina didn't say it. But I think is a really important thing for the defense bar to be aware of at this point. The court rejected our third assignment of error, concluding there was enough. Aggravatingly, they didn't explain what evidence was enough. They simply said, we don't think it would be helpful to the bench or bar to say what evidence we thought was enough. There just was enough. And then the court turned to the first assignment of error and declined to address whether the trial court erred in saying that the claims arose in the 1960s. the court's logic was it wouldn't matter because the jury ultimately found that the defendant engaged in conduct that we think fits in this third box. And if it fits in that third box, the entire statutory scheme of comparative fault is inapplicable anyway. I question whether you can, this all had to do with a motion in limine, and it's a little bit hard to lose on a motion in limine and say that is all rendered harmless by the jury's verdict, because the jury's verdict was impacted by what they did not see and were not asked to do because of a granted motion in limine. But that's not quite the subject of this talk. The real takeaway here, at least what I think is particularly important for the bar, is this is the first time that that any of the appellate courts in Oregon have said it's okay to ask the jury to determine whether the defendant is reckless in its negligence, which, by the way, is a phrase that has never been used in Oregon law before this year. And it's okay because reckless and wanton mean the same thing. And therefore, you can, by having the jury conclude that the defendant was reckless, render unavailable all of the ordinary comparative fault schemes in Chapter 31. That's new. That was not the state of the law before this case. One thing I think we need to be really cautious of going forward is the courts like to talk about these 4 boxes historically, but the courts have been sort of the worst actors of all in using these terms really inconsistently. Using reckless where they mean negligent, using careless where they mean negligent, using reckless where they mean wanton, using grossly negligent when they mean wanton, and vice versa, using willful, which the court in this case said doesn't mean anything at all. Words matter, and this case is a really good example that we shouldn't just toss around a term like wanton or willful or reckless or grossly negligent without being really, really deliberate about what's intended, referring to what you actually mean by that term. I also think it's really important to be careful about not conflating the difference between, on one hand, whether the comparative fault statutes are available, which depends on what's alleged. It can't depend on what's proven because you're not there yet. Jury hasn't even rendered a decision yet. And on the other hand, whether defendant will actually be held jointly and severally liable, which does depend on what's proven, not what's alleged. And in this case, both sides' trial counsel were, I think, less than clear about that. And I think some of the problems that arose on appeal could have been addressed earlier, or at least more cleanly, if we are more deliberate and precise about terms and about distinguishing between whether the comparative fault statutes apply and whether joint and severally, or whether the defendant will be held jointly and severally liable. Just as a last note, Kaiser Gypsum is petitioning for review. None of what I've said today is intended to discuss what we may or may not be arguing in our petition for review, which isn't filed yet, but is intended to reflect what our client's position is about the case, which I think is a matter of public record anyway, because we filed briefs in this case for a long time now. And so none of this stuff is confidential. This is all out in the open. And I think, hopefully with that, we have a good groundwork to have Jonathan and Sarah talk a little bit more about the implications and sort of concerns going forward, what this might mean for defense counsel in similar cases, because I think this is the sort of thing we're going to see more of going forward.
I guess I'll jump in here too. Thank you so much for that, Aaron. The brilliant recitation of where we are in the law. I appreciate that. I will say that where we're going to see this is probably where we see a lot of new case law, and that's where plaintiffs' counsels may not fully understand all of the issues, so they throw as much at the wall as they can, hoping something will stick. Or they'll throw it in a demand that says, your client was reckless, there will be no comparative fault, so pay me all this money, kind of like a negotiation tactic. I know I was seeing this 2 years ago or 3 years ago when Gutierrez came out, and then since then the pandemic hit, and it's almost like, and I don't know, maybe you guys all can talk about what you've seen, but that didn't pick up in the as fast as I thought it would be picking up. But with Miller coming out now, which kind of reaffirms the Gutierrez decision in some respects, I think we're going to see it a lot more often. The way that I came into contact with this case is I represented someone who was convicted of DUI who hit two pedestrians on the highway, who also happened to be highly intoxicated and crossing in an area of the road where they shouldn't have been crossing. So you had comparative fault issue for sure. He wasn't convicted of any vehicular manslaughter because even the law enforcement determined that a sober driver would not have been able to avoid the accident. So plaintiff's counsel argued either your client was so intoxicated, which he was, it was a 0.22, that he was reckless in his conduct, therefore comparative fault should not apply. We argued this issue to Judge Odin Orr in Multnomah County, who said, I do find that as a matter of law, your client's conduct was reckless. However, there are remaining issues to be decided. And that would be whether or not he could have avoided this accident, or whether or not his reckless conduct caused the accident. We also argued that it was something that should apply post-verdict. So once the jury decided if there was negligence, causation, recklessness, and divided the percentage of fault, then it should be dealt with the courts after the verdict. So just like we do with the wrongful death statute. One of the reasons we also argued that is because we wanted the evidence to come into the jury. They were going to try to argue to the court that it shouldn't even be a question that's presented to the jury. One of the things that I took away from that is if you have a plaintiff whose conduct is reckless, you need to also allege that. If you have competing reckless parties, we don't know how the court is going to decide that. And I know Jonathan just had a recent case where that might be relevant, where defendant's conduct was not necessarily reckless, but maybe plaintiff's was. So consider whether you need to allege it as a third party or a cross claim, or whether or not you're going to put it as an affirmative defense. But if you think that there's a possibility that plaintiff was also reckless, then you should allege it. And as Aaron talked about, is the statutory scheme as how it was presented, how it presents now. The Oregon legislature did that to prevent against unjust results. So if you go way back and you say, okay, why do we have this current scheme that doesn't allow for non-economic or allow these comparative fault for reckless conduct? It's because they didn't want an unjust result. And if you have two parties that are reckless, yet one can't claim comparative fault and the other one can get away with that reckless conduct, that's also an unjust result. So I anticipate we'll get that. It'll eventually go before the court, but I think that should be certainly alleged. And Jonathan can talk about the kind of where we're seeing trends in comparative fault and why that might be important in other types of cases too.
Thanks, Sarah. I was going to make a point similar to Sarah's in that what I immediately thought of after this case was, well, what if the plaintiff has acted recklessly? What does that mean? And I agree, it's so unsettled right now. I would allege it, and I would counsel people to allege it. And I think a case like Sarah's would actually be a great case factually to make that argument. Maybe, Sarah, it sounds like does a good deal of dram shop litigation. My office does too. And one of the things you learn doing dram shop litigation is a significant number of people out late at night are intoxicated, whether they're driving or walking. So it's not uncommon to have a dram shop case in which both drivers are intoxicated. It doesn't happen all the time, but it's not uncommon. And it would be a case like that I would think would be a good factual case to make a run at this argument that, look, similar to what Sarah was saying, it can't possibly be that both of these drivers are reckless and one of them is injured, but there's no allowance of, or no consideration of comparative fault. And so I would say, yes, let's allege that. In terms of the trend, when we were discussing this before this CLE, I had noted that anecdotally, I haven't seen any data on any of this stuff, but at least anecdotally, it seems like, at least in this area in the Northern Valley, it's getting increasingly difficult to prevail on a comparative fault defense. And there are a lot of cases in which the plaintiffs or the jury will allocate a significant amount of fault to the plaintiff, but not over 50%. And in a lot of those cases, it seems like where there are these larger allocations, it seems like a case could be made that those plaintiffs were acting recklessly. I'm thinking of like the TriMet cases. I don't know the facts all that well, but I recall there being discussions on the listserv about folks, ignoring signage and having headphones in and their hoodie over their head and walking past a gate that says they're not supposed to enter there and walking onto the train tracks and yet still recovering. And so there may be some things like that in which you can make a pretty good argument that the plaintiff acted recklessly. Now, I don't know what that means. If you could get a special interrogatory to the jury and the jury concludes that the plaintiff acted recklessly and that reckless conduct was a cause of plaintiff's injury, what that means, or whether what we were toying with was, is this an affirmative defense or is this a claim? How do you present this to a jury and what does it mean? All of that stuff is up in the air. I'm not aware of any cases, even since Gutierrez Medina, that have tried this type of stuff, and certainly not since the Miller case, but it's all coming. And I agree that now that, so the Gutierrez Medina case was a criminal case, so it kind of flew under the radar, and it came out, as Sarah noted, not long before the pandemic closures and the working from home and so forth. And so it really kind of flew under the radar, but I was still surprised that it took 2 or 3 years to start seeing really some more push on this front. But now that they've got a civil case, now that there's a civil case that squarely addresses this, and what I would anticipate is that the Supreme Court would accept review. I think there's a pretty good shot of that. That depending on the outcome of that case, and until the Supreme Court says something otherwise, we're going to see a lot of this. And I agree with Sarah that we're going to see a lot of plaintiffs just throw in allegations, kind of like almost like a punitive damage allegation at the very end of the complaint that just says, oh, by the way, you also acted recklessly and or wantonly, and so there's no comparative fault. We might even be able to see motion work, moving against if comparative fault defenses and some real aggressive motion practice from plaintiff's bar. There's a little bit of that going on now with respect to other affirmative defenses. What my office has experienced a couple of times now, plaintiffs moving against a failure to state a claim affirmative defense immediately, and you get the complaint, you file an answer, you include it as a affirmative defense because you've got a 10-day notice, and then they immediately move to strike the defense. So I could see some motion practice coming out of this in that regard too. But we're still working through a lot of the issues, like Sarah touched on this as well, whether this is a deal where you instruct the jury and you tell the jury what's going on, and if they find recklessness, then there is no comparative, so they don't need to move on to the allocation, or do you have them do the allocation and then have a special interrogatory asking about whether or not the defendant acted with the requisite level of culpability, whether it's wanton or recklessness, and then have the court reduce, or the court essentially enter a judgment for the full amount and disregard the allocation, which of course could lead to results in which you have seemingly conflicting, you have a verdict that says plaintiff's 45% at fault, but defendant acted with recklessness, and so there's no comparative. We don't, that's another issue that's going to have to be resolved, and will probably come up. A lot of these issues I anticipate will come up before we get a decision from the Supreme Court, even if the Supreme Court accepts review now. because I think we'll see more and more of this, and it will just come up. So the case, I see there's a question from someone. There's a case, a 1970s case. Is it Cheney? Aaron, you might be able to help me. The case that in which the court held that the comparative fault scheme applies to product liability claims, even though it's a statutory claim. I believe that's I can find it quickly, but it's a 1970s case. I believe it's a Cheney. This begins with a C. But there's also a recent Court of Appeals case that you should be aware of. That I need to look the name of this one up too. But there is a recent, within the last 6 months, a Court of Appeals case in which the court held that the comparative fault scheme does not apply to statutory claims under the Residential Landlord Tenant Act. So you'll definitely want to take a look at that case if you're concerned about whether the comparative fault applies to statutory claims. You'll want to look at both of those cases because they reach different conclusions.
There's also a good follow-up question here from Alan saying, what would be a better definition of reckless to propose in contrast to Miller's wanton-like definition? I think this actually touches on a really important point, which is it is not new, in my view, it's not new law that sort of boxes 3 and 4 are describe conduct to which comparative fault doesn't apply, and boxes 1 and 2 describe conduct to which comparative fault can apply. I think that's not new. What feels new to me is as a use of terminology, and particularly the word reckless. I think I'm not a trial lawyer, and so my sense of what juries think is no better than Joe on the street. But my sense is that people have tossed around the word reckless to mean not very much. There's a Supreme Court case in this line of cases that notes somewhere around 2/3 of the complaints used the word reckless to refer to negligence when they really meant just negligence. And this was 50 years ago, but people think of that word as having a different bite to it, maybe being broader and less bad. Whereas the word wanton and willful, to my ear at least, implies you really meant to hurt someone, which exactly is the way it's defined. And so what I think is newly available after this kind of decision is that a plaintiff could ask the jury to make that finding under the guise of a word that sounds a lot softer and a lot easier for them to swallow, being reckless. And so I think the answer might not be, to answer Alan's question, the answer might not be to give reckless a different definition, but to say, if you mean wanton, which is the term that the Oregon cases have used for decades and decades and decades, then say wanton. If you're gonna instruct the jury to find, to determine whether the defendant acted in this third box, that's called wantonness. And I think calling it by its name matters. Allowing the plaintiffs to call it recklessness, particularly if the Court of Appeals decision is, even leaving the Court of Appeals decision in place, wanton is obviously the more common and usually applied term, and I think it ought to be a winning argument that if the jury is going to ask the plaintiff's going to ask the jury to be instructed on the issue, it ought to be called wantonness.
And I think that's a great point, Aaron, because that's what your case is about, was they got rid of that wanton allegation at the last minute. So when you are talking to the court about whether or not this comparative fault statute should bar comparative fault, then you can say, if plaintiff wants to make this argument, it needs to be properly pled. And here's how it needs to be properly pled. Then by the time you get to jury instructions, that's the jury instruction that you're asking for. So I think that's a really good point. Someone had a question here about whether or not you have multiple defendants where one's reckless and the others are not. That's interesting because that's the exact situation I had in our case, where we had one of the plaintiffs was guiding the other plaintiff across the street. Like, so kind of was like, go, go, go. So one of the plaintiffs was more comparatively at fault and was reckless than the other, but both were obviously highly intoxicated and not using good judgment. And so that was something we talked about to the court where, hey, you can't decide this now. You have to wait for a jury to decide. And then once the jury decides, we have to figure out what we're doing with all of this fault. But I think it's a huge question mark, a huge question mark.
Megan raises a good point about contribution. That's interesting. If the comparative fault scheme is out and joint and several is in, then it seems like the purpose of contribution is back, and the Lasley line of cases that essentially eliminates contribution shouldn't apply. So in the context of where there's two defendants, one is only slightly negligent and the other one is wanton, so that there's no comparative fault. If there is a large allocation, or if the defendant who is only slightly negligent ends up having to bear the brunt or a large portion of the allocation, it seems like they ought to be able to bring a claim for contribution against the wanton defendant and seek recovery that way. I don't know if that would help. In a lot of dram shop cases, it wouldn't get you anywhere because you get a judgment against somebody who's not going to be able to pay it, and it wouldn't do you a lot of good. But that is interesting about using contribution, which is frequently contributions not allowed as for instance like a cross claim, in a lot of cases not as a third party claim if the parties are already, if the defendant's already in the case. So that could be one way to try to deal with that, to deal with this, for the inequity that might occur if there are two defendants and one ends up not getting a reduction for comparative because the other defendant is reckless or wanton.
Looking down the list, I'm going to hop over Mark Fusili's question just for a moment. David Jacobs, Steve Cade, and Timothy C., who I don't think I know, have all asked a really similar question, which is, what happens when you have multiple defendants and one of them is found wanton and others are not? How does allocation work? And I think the answer is a big fat I don't know. I don't think the Court of Appeals knows either. The court actually referred to that issue in its opinion at footnote 4, saying there are practical ramifications to this that could be a little troublesome. And I think they see on the horizon that these problems are out there. I think that's one more reason to pay close attention to this. I think all three of those questions, well, what about where defendant 1 is this and defendant 2 is that? It makes allocation really, really difficult. As to Mark Fusili's question, he says, if a defendant in an asbestos case puts a warning on the product packaging before the plaintiff's alleged exposure, do you think that makes the defendant not reckless as a matter of law? I think all of that depends on what the plaintiff's theory of negligence was. Sometimes their negligence is going to be failure to warn. Sometimes it's going to be merely including asbestos in a product during a time when that should have been understood to represent harm. It's all going to depend on what the plaintiff alleges. I don't think any of that stuff raises to the level of wantonness, but I'm not exactly an unbiased observer on that. So
I will say too, is when you're making your arguments, quote the specific language of Gutierrez, which says, at least under these facts, right? So the court is as saying that maybe there's a narrow set of circumstances where this could apply. So if you want to make an argument that's outside of the box, that's outside of those circumstances, you can use that language to say this is only meant to address these specific things. I guess it's harder with Miller coming along, but take a look at like the exact language as to in those cases, and then how does that apply to your case?
No, I agree. It just got a lot more difficult for defendants after Miller, because the Gutierrez decision, you could almost shrug off and say that's a criminal case in which the court held that a convicted criminal defendant doesn't get to reduce the amount of restitution he owes to a victim because of an allegation the victim is comparatively at fault. That seems like the right answer, but that's different than what we're dealing with. Here or now, and so after Miller, it might be a little more difficult. But you definitely want to read Gutierrez and include it in any discussion. I'll just backfill a little bit on what Aaron said at the very beginning. After Hampton in 1999, there was a case called Shin versus Sun River Prep. And in that case, the Court of Appeals took on this issue, what Aaron's been referring to as 4 boxes, and concluded, this is kind of really the beginning of this issue, in my mind anyway. And this is in 2005. And there concluded that you don't compare the fault of an intentional tortfeasor with those who are negligent. But in that case, the court again looked to Hampton and again reiterated and made a distinction between intentional torts and negligence, which it described as a continuum, beginning with simple negligence and up to and including reckless. It said reckless was part of negligence. So this is one of those, as Aaron's pointed out, this is where the courts kind of get a little sloppy with the wording. And there's a lot of different areas of law where you can pull from that are defining or talking about reckless. And so, for instance, when it comes to punitive damages, plaintiffs usually argue that reckless is really just negligent. I mean, evidence of negligence gets you there. You don't really need much more to show that you've met the standard for punitive damages. So, for instance, on a motion to amend to add punitives, usually evidence of negligence is sufficient. But here they got to argue that reckless is something above negligence and separate, and that's why it shouldn't be, recklessness can't be considered with negligence. And so maybe that's the cause of the confusion with the terminology. But there are, it was a little surprising because there were cases from the Court of Appeals in which the court held that reckless was really just a species of negligence. But it seems to have changed, and that may not be the case anymore.
Looks like our last question before we wrap up is from Megan Yulee. She says, is there any alternative mechanism to prevent plaintiff from obtaining a double recovery from pretrial settlements if comparative fault doesn't apply to the last defendant standing? Because the existing comparative fault statutes will allow you to reduce the liability of the last defendant standing by the amount of settlements received by the plaintiff. I haven't looked closely at this issue. Sarah, you might have a better beat on this than I do. My sense is that what the policy that the statute reflects is the policy that would be in place even without the statute, because at very least as common law, even equitable matter, that would be there are all kinds of sort of common law equitable mechanisms that prevent that kind of unjust windfall. And I think even without that statute in place, the plaintiff wouldn't be entitled to a double recovery. But I'm kind of talking out of my neck there. So I don't want to get I don't want to act as though I have any more authority than I do. Sarah, have you seen that occur?
I think Jonathan has something as deep.
Well, so I mean, I was going to say the argument only that, hey, plaintiff's going to get a windfall here probably doesn't. I mean, I'm thinking of the White v. Jubitz line of cases where the write-offs and where the court said, so what? So the similar argument was made there. Look, this amounts to a windfall for the plaintiff. They're recovering more than more than they ought to, and that didn't bother the court. So you have to come up with maybe something else. What I was looking at is this kind of interesting issue to me in Megan's question regarding contribution as between two reckless defendants. And if both of those defendants were taken out of the comparative fault scheme and were jointly and severally liable, that was the original purpose for contribution, was to resolve the inequities that were associated with joint liability. So if you're back in a joint liability, then why not? That you should or you ought to be able to recover contribution. There's one more question from Mark there, Aaron. I don't know if you saw that.
Oh, Mark says, if the old law of joint and several liability applies, does the reckless defendant get a dollar for dollar offset for prior settlement? That's a really similar question to Megan. You know, my answer would probably be good luck. But I think, Jonathan, you may be able to speak more to this because it hits on exactly the same point you were just talking about.
Yeah, I mean, I would certainly try that and say, well, if we're under the old scheme, then the old scheme is we get a set off for settlements. But I haven't seen it tried yet, or I you know, we'll see. I kind of agree with Aaron that that's probably a uphill battle, but I would certainly make the argument.
I'm really glad that people it was my hope that people would have a bunch of questions and comments like this. I think if we were to keep going, you know, for another half hour, people would have more questions, and I really like that. I'm glad that people were able to chime in. That was my hope. So thanks to everybody for their comments.
That's great. This concludes our webinar. A big thank you to everyone that's joining us. We had a wonderful turnout today. And thank you to Jonathan, Aaron, and Sarah for taking the time to put together this wonderful presentation and be with us today. Thank you, everybody. OADC will be watching this case very closely, and I would expect that if there's opportunities for a presentation down the road as the case progresses, we'll offer that to our membership. Thank you, everyone.
Thanks,
Thank you.
everyone.